Technology, Electronic Assembly and Management or Team Pacific Corporation was sued by Fruhop Electronics Philippine Corporation in March 1987 for unlawful detainer. Both parties signed a Memorandum of Agreement in an effort to settle the matter amicably. The team or the Technology Electronic Assembly and Management Pacific Corporation agreed to pay Fruhop 14.7 million pesos in outstanding rent as part of the Memorandum of Agreement. They also agreed to a 15-year lease that could be renewed for another 25 years if both parties settled with it. An arbitration clause was included in the contract. Fruhop launched a submission of an existing controversy for arbitration number 11449 before the Regional Trial Court. It claimed that when the lease expired, the property was damaged and needed renovations, that the Technology Electronic Assembly and Management Pacific Corporation failed to turn over the premises and pay rent when the lease terminated, and that the team or the Technology Electronic Assembly and Management Pacific Corporation did not restore the property to its previous conditions as required by the contract. The Regional Trial Court granted the petition and ordered the parties to follow the contract's arbitration clause. Following that, the arbitral panel awarded Fruhop an 8.2 million pesos in unpaid rent from June 9, 2003 to March 5, 2005, as well as 46.8 million pesos in damages.
Crim was still accountable for the rents after neglecting to surrender the property to Fruhop. Crim, on the other hand, can subtract rentals from Fruhop's fee if it can show that he reset them from the capital. The tribunal found out that there was an act of negligence on the part of the team with regards to the maintenance of the premises, pieces of machinery, and equipment. It was obliged to hand over to Fruhop. For this failure to carry out the required repairs or to inform Fruhop of their need, the tribunal held Crim responsible for the damages in place of the value of the repairs. The team appealed the RTC to somewhat vacate or modify the arbitral award. It claimed that the tribunal is unsuccessful to appropriately appreciate the evidence and the terms of the contract. The issue: whether or not an arbitral award is subject to an appeal or review by the higher court.
Ruling of the court. The arbitration law and the alternative dispute resolution law forbids a losing party to ask for a reconsideration of an arbitral award. It is a general rule that, either as to the law or facts, an award cannot be revoked for a reason of simple errors in the decision. Also, the courts do not have the power to modify or countermand merely because of the discrepancy of the law or facts. Whether Section 29 of the Republic Act No. 876 or Section 46 of the Republic Act No. 9285 is applied, ordinary appeal still has no legal basis in the correctness of the remedy involving arbitral award. The commission of the arbitral tribunal of mere errors is not subject to trial in the court of law. Concerning the case, Technology Electronics Assembly and Management or Team Pacific Corporation concurred with the submission of their disputes to the arbitral tribunal. Thus, the risks, which include the non-existence of the right to appeal, must be recognized. Therefore, the court set aside the decision of the Court of Appeals and reinstated the order of the Regional Trial Court affirming the arbitral award.